the initial 911 call that came in reported Mr. Luttrell engaging in some odd behavior, including crawling around on the grass, making comments about his daughter being kidnapped. And so certainly things that would lead a reasonable person to believe that he was suffering from some mental illness. Now, with that being said, he was also highly intoxicated, and we don't challenge that in any way, shape, or form. He admits to that. He understands that. He's been working on his sobriety since this occurred, so we're not arguing that he wasn't under the influence as well. But the request was really in the nature of getting him some help, more so than it was getting law enforcement involved because of any criminal activity that he engaged in at that time. It did result in a violent encounter with the police. We certainly understand that the court takes those things seriously, so we don't mean to minimize what occurred. There was some body cam footage of it as well. And when the body cam starts, you see Mr. Luttrell ordering the officers off the property. Officers obviously said it doesn't work that way. When he refused to follow their lawful command, specifically to get on the ground. That's what resulted in the confrontation with the police. He was physically.
Mr. Luttrell, you don't have to tell me anything today. If you don't, I don't hold that against you. But you may make any statement to me you wish. Is there anything you want to say, sir?
I just appreciate any considerations, and thank you for your time.
Buckle up, guys. Today, we're stepping into a case where a troubling 911 call quickly turns into a tense confrontation with police. The defense says mental health concerns and heavy intoxication played a major role, while the body camera account shows the situation escalating after Luttrell refused commands. By the end of this opening stretch, the judge is already clearly focused on whether Luttrell is prepared to face an old, long-standing Indiana warrant.
How willing are you to take care of this Indiana outstanding warrant?
I could take care of it as soon as I have this taken care of.
Well, I mean, you've been able to take care of that since 2017.
Yeah,
You failed to appear.
I did run from it. I admit to that. But
If I even consider putting you on probation, the condition is you got to travel to Indiana and physically own up to that warrant. If they put you in jail, they put you in jail.
Okay.
You're willing to do that?
I would be willing to do that.
Mr. Radsbot, any recommendations from you?
Judge, first of all, we agree with the recommendations of the department. And I think even with the recommendation for jail, some period of probation, I think, is important to follow up and make sure he is, A, continuing with his mental health treatment and his medication, and B, remaining sober. Judge, had he been following his medication regimen, we might not even be here today. If he had not compounded that mistake by then consuming alcohol to the point of intoxication without taking his medication, we probably wouldn't be here today. But the bottom line is he did both, and as a result put 4 officers at risk. Got into a heck of a tussle with the 4 officers, tried to spit on them. We can't have our officers subject to that, Judge, so some consequences is appropriate. They recommended 9 months. I guess I would leave that up to the court's discretion, but I don't think that's inappropriate. It's about the middle of the guidelines. And insofar as any lingering issues in Indiana, yes, he'll have to take care of it, but I think he should take care of what I believe is his obligation to the law enforcement here by serving some time in jail and with some probation on top of that.
From this point, the judge puts a spotlight on an Indiana warrant that has been outstanding since 2017. Luttrell admits he previously ran from it, and the judge makes clear that probation would require him to face that warrant in person. The prosecution also argues that supervision is necessary because of his mental health treatment and sobriety, while emphasizing that his confrontation with 4 officers cannot simply be overlooked. The warning is unmistakable.
Well, Mr. Luttrell, this is, not a complicated charge. Resisting obstructing police is a fairly complicated charge. It's a 2-year felony. The guidelines are 0 to 17 months. We see these types of cases a lot, and they're on a sliding scale of how, any failure to comply with a lawful command of a police officer is resisting obstructing that officer. Doesn't even require an assault, and here you were physically aggressive with them, threatening with them. So the charge itself is not that complicated. The the facts of you are what makes this much more complicated. I mean, the police are called to respond to some behavior that was at least partly driven by mental health concerns. But the prosecutor is exactly right. I mean, if you were following your treatment regimen and were sober and nonetheless had some mental break, I think courts would bend over backwards to try to find a way to work with that and to solve that problem. But the prosecutor is absolutely right. You decided to stop taking your medicine, and you decided to also get drunk. You're responsible for that behavior. You've got a prior R&O on your record. You've been on probation in the past, and you haven't done well with that.
Here, the judge explains why this case is more serious than the charge might initially suggest. He points to the felony classification, the physical aggression toward officers, and the circumstances surrounding Luttrell's mental health episode. But the judge also stresses personal responsibility. Luttrell stopped taking his medication and became intoxicated. His prior record and unsuccessful probation history make the court increasingly reluctant to offer another opportunity.
You have a charge for drunk driving in the state of Indiana that you fled from 7 years ago. And they have a statewide pickup outstanding warrant. And for 7 years, you've just been thumbing your nose at the court in Indiana. So you're aggressive and threatening to the police. You don't do well on probation in the past. You're thumbing your nose at a court system as we stand here today. And then you come here and you want us to help you. But what makes it tough is it's very tempting to do so. I mean, I've got some good letters from your employer. This was a couple of years ago. You've gotten back on your treatment, and you're engaged, you're working. I'm hesitant to kind of upset the apple cart with those things. I really am. But man, it's just really, really tough to go out of my way here for somebody who's going out of his way to avoid justice. You've been going out of your way for 7 years to avoid justice for a serious charge, driving under the influence with a high BAC. The people of Indiana have the right to have justice on that charge. I don't know if you're guilty of it or not, but they've got the right to have that charge go forward. And you're an absconder from justice on that charge. So I don't know. I don't think putting you on probation is a great idea. So there's fines and costs of $130, crime victims assessment $68, state costs $350, and court costs, and I'm going to order you to serve 6 months incarceration in the Presque Isle County Jail with credit for 4 days previously served. That is a sentence within the advisory guidelines. It's not an intermediate sanction. I'm giving incarceration because of the prior poor supervision on the outstanding warrant and the prior R&O.
Comment your opinion, like the video, and subscribe for more real courtroom moments.
The consequence. The judge weighs Luttrell's recent progress, including return to treatment, but says those positives cannot erase 7 years of avoiding the Indiana case. He ultimately decides probation is not appropriate and imposes 6 months in the Presque Isle County Jail, with credit for 4 days already served, along with fines and costs. Like the video, subscribe to the channel, and we'll see you in the next video.